Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We've received some questions regarding is voir dire, which is the process of jury selection, going to be a closed and sealed matter, or will it be open to the public? We need to refer to the redacted order governing further criminal proceedings and notice of trial setting. This was filed on the docket in Idaho versus Kohberger back on October 9th, 2024. I have repeatedly referred to this document. I call it the blueprint for the case, the pre-trial and trial order, because it literally establishes what the major actions and activities needed to happen pre-trial in order to prepare this matter for trial. And this is a jury trial. Therefore, the process of jury selection will be incredibly important, because the 12 people that are selected will be the triers of fact in this case, meaning the ultimate decision of whether Mr. Kohberger is adjudicated guilty or not guilty of the 5 serious felonies he has been charged with by operation of the indictment that was entered in this case against him. That decision is in the hands of the future jury. According to Judge Hippler's October 9th, 2024 order, it states, voir dire shall commence on July 30th, 2025 at 9:00 a.m. Common sense interpretation here, just by looking at that statement, is that the process of jury selection, which is what voir dire is, will begin at that date and time. There is no way of predicting how long it will take to select 12 jurors plus alternates. That must happen before the next item that you see on this page. The jury trial shall commence. No jury trial. So, the next question is voir dire closed and sealed, as many proceedings have been, including a very recent hearing? In this case, held May 5th, it was closed and sealed to the public. Will voir dire be sealed as well? Or will interested members of the public be able to witness voir dire firsthand by going to Judge Hippler's courtroom, and those of us who are not able to do so, those members of the public who would like to watch voir dire via the court's internet system virtually, will we be able to do so? You will see many, many things in this order directing that certain matters are closed and sealed. By way of example, just look at the jury questionnaires. Will be administered approximately. That is redacted. We do not know when those jury questionnaires going to the pool of eligible jurors in this jurisdiction will be administered or disseminated. We also, by looking at this court order, can see that both parties were ordered to submit their proposed questions for the jury questionnaires under seal, and there was supposed to have been a sealed and closed hearing that we learned only by looking at the case summary page was canceled. It is unknown if that hearing has already occurred at a different date or if it will occur in the near future, because there's no notice of cancellation and rescheduling of it anywhere on the public docket, and it's not noted here on the case summary page. But taking into consideration that there are other matters here that Judge Hippler strictly said, unequivocally said, was closed to the public, common sense would be that voir dire, at least at the time that this order was disseminated back in October of 2024, was to be an open proceeding. And we can look at what the Supreme Court of the United States has to say about voir dire, that it should be open to the public, by looking at a case entitled Press Enterprise Company versus Superior Court, 464 U.S. 501, 1984. That is the location in the U.S. Reporter where you can find this legal decision. It's also, if you plug in this term in any search engine, it might pull up the case for you elsewhere. But basically, what this case stood for is whether or not voir dire examination of prospective jurors should be public or private, closed. This holding states the guarantees of open public proceedings in criminal trials cover proceedings for voir dire examination of potential jurors. You can find that at 464 U.S. 505 to 510. Between those pages, 505, 506, 507, 8, 9, and 10 is where the court went into its evaluation of this issue. The presumption is of openness of voir dire, but the Supreme Court held that it may be overcome only by an overriding interest based on findings that closure is essential to preserve higher values and is narrowly tailored to serve that interest. You can find that discussion between pages 508 and 510, 464 U.S. 508 to 510 is where that discussion is. So it appears that in order to close voir dire, there would need to be findings of fact and conclusions of law by Judge Hippler that there was some overriding, very narrowly tailored reason for the process of jury selection in Idaho versus Kohberger to be closed to the public. As of right now, there's no motion by either side. There's no stipulation to close it. So until or unless something appears on the docket where the court has determined that voir dire will be closed, I think it's at least in my opinion, a good speculation, a good guess that come July 30th, that proceeding will be open to the public. If you have any questions or comments, please leave them here. My name is Kathy. Thank you for joining us today.